Hi everyone, am I audible? Kindly give a thumbs up if I'm audible to you all. Okay, great. Hi everyone, a very warm good evening on behalf of whole LeDroit India team. My name is Ria Chabra, founder of LeDroit India, and I'll be your host for the evening. So today we have gathered to learn about how to start with contract drafting, common mistakes in drafting a contract and how to avoid them. Before starting with the webinar, can I just know how many of you are participating in LeDroit's webinar for the first time? Kindly just raise your hand so that I can know how many of you are over here for the first time. Okay, great. All right. So to start with, I believe that a few of you are not aware of the LeDroid. So I'll start with the LeDroid's introduction, and then I'll explain you what are the things you'll be learning in today's webinar and much more about it. So LeDroid is an online legal education platform registered under Ministry of Corporate Affairs in the year 2020. We provide practical legal education with an aim of providing you for building that gap between the corporate world, the legal practical world, and what you learn in law school. That's our main aim, and that too at highly affordable prices. So to start with, in today's webinar we are going to learn about various things about how to start with contract drafting, importance of contract drafting, and also about common drafting mistakes that people do in drafting a general contract and how you can master these skills. Okay. Before this webinar, we have also conducted few other webinars on topics like how to start with legal drafting and intellectual property rights overview. In case you have missed out on those webinars, you can refer to them by visiting our YouTube channel. We upload all the webinar recordings on our YouTube channel as well. Now, coming on to the query which you many of you have raised, is that whether you'll be provided with the certificate for the webinar or not. So, yes, the webinars are completely practical and you'll also be provided with the certificate. But the only thing is that you have to attend the webinar throughout. Only students who have participated in the webinar till the end will be provided with the certificate. Towards the end of the webinar, we are going to share a feedback form. Only students who have filled up that form will be receiving that certificate. Okay, so kindly do not leave the call once the faculty explains you everything. Be on the call because then we will be sharing the feedback form. Is it clear? Are the instructions clear to you all? Just give a thumbs up. Perfect. Another thing is that mostly our webinars and classes are very much interactive in nature. We allow students to participate and unmute themselves and ask their query during the session. But for now, we have kept, considering the number of participants, for now, we have not allowed you to unmute yourself. But once the faculty joins, we will be allowing you, giving you that right to unmute, but kindly make sure that you are not misusing it, because the whole purpose of the webinar is to give you insights, to provide you practical knowledge, and to provide you a better understanding of career, okay, corporate world and all right. So I'll move on to the introduction of the speaker. The webinar will be conducted by Advocate Mrunmayi Vatkare. She has got 5+ years of corporate experience and is an alumni of Queen's Mary University, London. So moving on to webinar details. Let me just see whether faculty has joined the session or not. I'm just giving her the rights for the same. Meanwhile, if you have any queries or any questions, kindly drop the same in the chat box. So another thing is that we had shared a WhatsApp group link for the students who want to attend the webinar. We had shared a WhatsApp group link. The thing is that you'll once the webinar is over, we'll be updating you in that group that we have shared your certificates. So if you have not been added in the group, or if you don't have the link of the WhatsApp group, kindly join the same. Okay, so will you be getting any written material as reference? So let's see what material faculty is sharing, which I believe that there will be one document which you'll be receiving as reference, and you can refer to it. We'll be sharing the same in the group along with the recording of this webinar, and in the group itself we'll be updating you about the certificates and all. Okay. So, till the time faculty joins, let me give you an insight on the corporate world and how it works. So, majorly, can I just know how many of you are interested in creating your career in corporate sector? Kindly just raise your hand, those who are interested in creating your career in corporate sector. Oh, I can see that majority of you want to create your career in corporate sector. You have like till now, I believe you must be aware that contract drafting is one of the most essential skill you need in order to create your career in corporate. It just not only helps you in corporate sector, but also if you want to go for the positions like in-house counsel, or if you want to work independently as a litigator, this skill will help you over there as well, because drafting, whatever lawyer you are, be it you are working as a litigant or whether you are working in corporate, you should be aware of drafting. And drafting can be of two types: one is contract drafting and the other that helps you in court. So okay, so in LeDroit we provide you both the skills. We have practical courses for both the skills. Now contract drafting can help you a lot in your legal journey. It is just not limited to drafting a contract. There will be other additional skills that you should also be aware of if you're planning to create your career in corporate, such as you should be aware of how to do contract negotiation. You should be aware of how to there are other fields like you can apply for roles as legal analyst, contract analyst, and so there are predefined roles that particularly focus on contracts only. So if you gain advantage on this skill, if you focus on this skill itself, you will be able to get a good position in companies. In fact, IT companies also hire lawyers who have expertise in contracts. There are different type of contracts ranging from master service agreement, non-disclosure agreement, and IT agreements as well, such as your software license agreements and much more. So contracts are in itself a very vast range, and having expertise in this, the earlier you start, the better it will be for you. It will help you in gaining internships, it will help you in working as a freelancer, it will also help you in getting a job in corporate sector. So by this you can understand its importance, that it's just not a skill, it's more like your bread and butter. It will help you a lot in your legal journey. So I've already given you many insights on the same, and I'll continue on it once the faculty has started with the webinar towards the end of it. Just allow me a minute so I can hand it over to her now. Hi, ma'am, are you there on the call?
Hi, good evening.
Hello, good evening. So, just to give an update to the students that you can now unmute yourself and interact with the faculty. Kindly don't misuse this, right? Because if you are going to do so, we have to remove you from the meeting. And also, please don't use sticky notes or the whiteboard. It gets very much disturbing for us. So, please stop using whiteboards. That's all. Ma'am, over to you.
Okay, I can see someone using the whiteboard. Can you please stop it so that we can begin with the webinar? Okay. All right. So first of all, good evening, everyone. I am not sure if I'm introduced to all of you. My name is Advocate Mrunmayi Vatkare. I have done my BLS, LLB, and LLM from Queen Mary University of London, featuring comparative and international dispute resolution. My specialization lies in arbitration agreement, especially international commercial, and international investment treaty arbitration. I have experience of 4 more years in contract drafting, and now since 2 years, I've been teaching international contract drafting. So, welcome to the webinar, everyone. I am sure it's going to be an enlightening webinar, and you're going to, I would say, you'll be introduced to a lot of new concepts in this webinar. We're going to keep it more interactive rather than more theory based so that you understand the practicality of drafting a contract. Now, when you say drafting a contract, I want to just understand how many of you here are students or someone from non-law background or never worked in any firm or have no understanding of drafting a contract.
Yes, I'm not part of law firm. I used to work. I'm part of a procurement team.
Okay, no problem. So just put it in the chat box. When I ask questions, try to answer with the chat box, because the reason to that is we are a lot of people in number, so that we can, interact really well and I understand who's speaking what. I also get your names in that way. Okay. Okay, perfect. I see majority of people are law students here, and people who have no background or any experience in drafting contracts. Now, yes, let me start when I started my career as a lawyer. I think 7 years, 8 years back, I finished my law school. And at that time, if anybody would have asked me to draft a contract, I would have, I would have been scared to until death. Because the thing is, in law schools, we are not, especially in India, we are never taught how to draft a contract. I hope everyone agrees with me on this part, right? Yes. So, yes, I can feel you. But trust me, contract drafting is not a very difficult job. If you know how to draft it, and if you understand the skills which are important for drafting a contract, it is not a very, it's not rocket science. Let me tell you that. Now, today's topic is what are the common mistakes one can make in contract drafting, okay, and how one can avoid it. Today, we are going to discuss in the first part. I'm going to divide this class into two parts. It's not going to be a very long webinar, but first, we are going to go through a document. Okay. Now, this document comprises of what are the common mistakes one could do. And we can see what are the key considerations related to it. I'll make you understand the same with the help of an example as well. And eventually, once we do the document, we will go and understand the case studies which are related to it. I'll take up 2 or 3 case studies as time permits, and I'll explain you how these common mistakes, which are very silly mistakes but can cost you millions and thousands of dollars. So that is one thing we are going to see today. Does anyone have any questions before we begin? Anyone wants to ask anything? You can just put it, okay. While I'm explaining anything, you can just put your doubts in the chat box. I will take up your doubts. If I'm speaking, once I finish, I'll take up your doubts. Is there any difference between legal and contract drafting? We'll talk about it when we speak about language. Okay. Language has a very important role in contract drafting. So today we are not going to see how to draft a contract, but what are the common mistakes? We are going to identify the mistakes and we are going to see the consequences. Now, so whenever you start drafting a contract, first you should start with reviewing a contract. Okay, you can't just start drafting. You have to read, right? So basically, when you go for exam, you read first, you learn first, and then you go for exam. So contract drafting is nothing but going for exam and taking that exam. But before that, you have to understand how a contract is drafted and what are the possible mistakes one could make while drafting the contract. Don't worry if you do not know contract drafting. Contract drafting is the ultimate goal. But first, there are certain steps which we need to understand. Okay. Now, let's say if I tell you to draft a contract for an for an employment purpose. Does anyone know what is the contract you will be drafting?
Ma'am, we have to add clauses like regarding the
No,
employment
I'm
and for
asking the
the
title of the contract. Does anyone
Employment
know?
contract.
It is called employment
Agreement.
contract. Employment contract. Yes, Anushka, you are right. It's employment contract. So when you're drafting an employment contract, okay, if I tell you to draft an employment contract, will you be able to draft it? As someone who has legal knowledge, who has understanding of laws, will you be able to draft it? No, no, right? Has everyone in the class studied labor laws? Are you aware about labor laws at least? Yes, most of you have studied labor laws. So here, if you understand, you actually know the basic part of drafting a contract. First, you have to see what is the contract you're going to draft. Then you have to relate it to the applicable law. Here, when you talk about employment agreement, the applicable law, there are multiple applicable law, but I'm giving you an example, labor law. Labor laws are going to be applicable when you are employing someone. So when you draft a contract, what is the first thing that you find very challenging? What is the first thing? Okay. When you think of contract drafting, what is the first thing that comes to your mind?
When the contract is commencing,
Commencing? No, but I'm talking about drafting of contract. If you have to draft, what is the thing that comes to your mind? What is something that you are scared of, or something that, you know, uh, is something that is a blockage for you to draft that contract? When you said that I won't be able to draft the contract, why won't you be able to draft the contract?
Maybe
You,
conditions.
you don't know the terms and conditions, but terms and conditions will be, let's say I give you the terms and conditions. Yes, you do not know the format. You don't know how to start, right? So let's say if I give you the format, if I give you a sample, will you be able to draft? Anusha is saying terminology. Okay. Yes, little bit. But what is going to stop you from drafting properly? Yes. What we should consider as is the most important aspect while drafting that contract. Very true. You do not know the aspects, right, while drafting a particular contract. So you would need a very specific understanding of the clauses that are required for drafting that contract. Maybe with the sample you have, you will be able to understand what are the specific clauses you need to or require to draft a contract. But the main problem comes with the language. Especially in India, when I talk about language, Indian contracts are drafted in legal English. Does everyone agree? Yes. So when you say legal English, it is little bit tough to understand legal English compared to formal English. Formal English is something that is known to everyone. Everyone speaks in English and understands English. But do you really think someone who's not from a law background or not from a legal background, who has never studied law, will be able to understand or uh, comprehend what a contract is trying to say? No, right? They won't be able to. So that is the fear everyone has. I mean, when I started as my, as a legal professional, this is this was a major challenge I was facing. What do you think? Do you face the same kind of challenge? Yes. So understand one thing, that the language comes with practice. It comes with
നിങ്ങൾ
practice.
ഇനിയും ഉണ്ടാക്കാൻ പോകുന്നല്ലോ കുളിക്കാൻ
Okay. And
പോയി
here we are not going to specify on. Prasad, please mute yourself. So when we talk about language, language comes with practice. So first I want to assure all of you that you should not be worried about the language. Okay. What you should worry about when it comes to drafting is not the language, but being extremely precise about drafting. That means you have to be very clear when you're drafting a contract. Understand this. The terms and conditions, the clauses, any information you're putting in your contract has to be clear. Let's say, very basic. If you're drafting an employment agreement, there are going to be two parties. There can be three, but I'm giving you an example. There are going to be two parties, party A and party B. So when you are drafting, for example, the parties clause, which defines the parties to the contract for the employment agreement, you have to be extremely clear with their name, designation, their address, their capacity, everything. Am I clear? So that is rule number one, is you cannot be ambiguous. You cannot be vague about what you're drafting. Right? Clear? So this is a rule that must be followed when you're drafting a contract. And people generally, when they're drafting, they avoid concentrating on, unambiguousness of the contract, and they concentrate more on how well it can be drafted in words. No, we do not need the words. We need a proper, clear agreement which can be interpreted by the court in a very clear and only one directional way. When I say in one direction, that means it cannot have two different meanings. Am I clear? Understood? Clear with this first point so that we can start with the document.
Yes, ma'am.
Perfect. Is my screen visible to all of you?
Yes, ma'am. Yes, ma'am.
Just hold on. So before I show my screen, I want to ask one more question. What is the one thing that comes to your mind, or what is one thing that you find difficult when you're drafting? Language is one thing. I think language is the most common thing. Why I'm asking you this question is because there are so many people in this class. There's so many student participants in this class. I want to know what is your understanding? What are the difficulties you face? The exact sentence, very good. The exact sentence to be formed again goes back to the language of the word, right? So this language drafting part will only come with practice. For that, you need to understand the basics of the contract, why you're drafting this particular agreement. Once you understand why you're drafting this particular agreement, you'll slowly understand what is the scope, who are the parties, what are the rights and liabilities of the parties, and stepwise you'll get to know everything. So you need a very specific analytical lens when you are drafting a contract. Okay. Now, which laws will be attracted? Okay. When, let's say, we are studying employment agreement. Okay. If it is an international contract, you'll have a governing law clause, which will give you the jurisdiction of the contract. Based on the jurisdiction, whether it be international or Indian contract, you have to look up for the laws that are related to labor law. Let's say if it is a sale of goods contract. Okay. In this case, if you're drafting an Indian sale of good contract, what are the applicable laws? You have to look at the nature of the contract, apply whatever you learned in your law school, and then look up for the laws. The applicable act will be the Contract Act and the Sale of Goods Act. Yes, very good. So this is how you have to analyze everything step by step. Once you get that, then what we do is we get in touch with the client. We get in touch with the client and we get the information from the client, and accordingly we draft the contract. Now, this is about drafting the contract. Let's now, with this document, focus on What are the common mistakes? Am I clear? Does anyone have any doubt until here? Everyone has understood?
Yes, ma'am.
Perfect. Perfect. So here, the common mistakes in contract drafting and how to avoid these mistakes. So we'll see a table which I have formed and drafted for you guys, where we are talking about the common mistakes, key consideration, and I'll explain you what is correct, incorrect with an exam. Okay. Proficient contract drafting is a fundamental skill for legal practitioners, because without, see, if you want to have a career in contract drafting, then okay, please guys do not use the screen as whiteboard. Am I clear to all of you? It's very disturbing for people who are paying attention. So please do not do that. Okay. So proficient contract drafting is a fundamental skill for legal practitioners. Yet even seasoned professionals may encounter challenges. So understand this. Drafting contract is not something you can learn within a minute. What you can learn is something that are skills which are related to drafting. And the actual encountering challenges, or understanding how a contract is drafted or getting well versed with drafting a contract comes with practice. But what you need to identify is the skills, or what you need to grasp are the fundamental skills which are important for drafting a contract. So today one skill you are going to learn is what are the common mistakes. Okay. Generally, people focus first on the contract drafting part, but we are going to first identify the common mistakes so that you can avoid it when you are learning how to draft. Yet, even seasoned professionals may encounter challenges that result in disputes, unintended liabilities, or unenforceable agreements. Now, when you draft a contract and you forget the basic idea of getting into a contract, what will happen? The contract will fail. If you make any common mistakes, any of the following common mistakes, which I'm going to explain you, what will happen? The contract will fail, and the whole purpose of getting into a contract would fail. Just a very basic question to all of you. If someone is hiring you as a lawyer, there is some idea behind it. And here the idea is to draft a contract which is going to last forever, right? At least until the term that is mentioned in the contract. And if that is not satisfied, the contract is going to fail. And what are the consequences? Your party is going to face losses that is different. What is going to be your loss? Your loss is going to be the loss of your client. The client is not going to come back to you. So it's an entire vicious cycle. So if you draft a good contract with understanding the intentions, understanding the scope of the contract, considering every possible mistake that can happen, avoiding all the common errors, you can create an amazing contract which can fulfill the purpose for which it was drafted. Okay. The table below outlines common errors, key considerations, and illustrative examples. Let's start with the first common mistake. Ambiguous language, something we have discussed, right? It is basic. Employ precise and well-defined terminology, specify time frames and conditions explicitly. What do I mean by be precise and well-defined terminologies? Anyone?
In short, ma'am.
I would not say in short. Not in short, because see, if you say in short, then there is also a possibility that you can miss out on a lot of things.
Being direct.
See, when you say exact manner,
It's a
sorry,
brief
someone was
note.
saying something, I missed it, I think.
It's a brief
Uh,
note of it.
Specific time period, mention the specific days.
Yeah, that is an example you're giving. You're absolutely right when you're giving that example. Yes. Specific time, yes. Obviously, it means that. But apart from that, so when I say
Use
be
of
precise, see, you can't be vague when you're talking about something. Let's say you're talking about an employment of a particular person for a particular position, you're going to explain that position. If you're explaining some other position related to that person, okay, maybe that person is taking another position also in that employment, but that is a different employment contract. And that makes no sense to the employment contract you're talking about or you're drafting. Just an example. Do you guys know any of this example? If anybody who has understood what I'm trying to say can explain with their understanding of example.
Well, as soon as possible does not specify. There may be
Yes,
different. Yeah.
yes,
They
perfect.
may take 5 days, 7 days,
Yes,
4 days.
yes, yes. For example, if you want to specify a time period, okay? If you want to specify a time period and you are saying as soon as possible the goods may be delivered, or as soon as possible the employment might start, right?
use of shall and will.
Yeah, right, right. So in this case, what you're going to do is you are not going to use any terms. Yes, very nice, Nayab. You're saying that there shouldn't be two possible meanings. Any sentence that you form should not have any other possible meaning. Am I clear? When I say precise, I don't say in short. No, you don't have to be short. Where you
Ma'am,
have to be
whenever we will
explanatory.
be like drafting contracts,
Yes,
like whenever we will be drafting contracts, so we will take help from the general clauses that which clearly defines the words and its
right,
meanings, and it will avoid the vagueness and it will avoid the ambiguity in the contract.
right. You're absolutely right. So yes, there that is definitely you have to consider. Okay. And apart from this, one example I'll give you, okay, about ambiguity and see something that is not related to law as such. Why I'm saying this is because um, does everyone know NASA?
Yes.
Yeah. So in 1962, NASA had launched a spacecraft called Mariner 1. It was called Mariner 1, which was intended to explore Venus. I'm not sure, but I think Venus. However, once just after minutes of launch, launch after the spacecraft was launched, the spacecraft veered off. It took a wrong turn, and NASA had no choice but to destroy it midair, immediately, in midway. What was the cause of it? Why did this happen? The reason was so basically the entire procedure of launching and everything is based on how the direction, how everything will work is based on the codification of the software that is used. There was a single hyphen that was missed in the code, which disrupted the spacecraft's navigation system. It was supposed to go straight, but it went on the right. And this tiny mistake costed NASA $80 million. And forget about like the setback they had to face. because so much money was lost. So many creative minds were involved. Time was invested only because one hyphen was missing in that code. So this is what one hyphen can do to a spacecraft. So you understand, see, this is not something related to law, definitely, but you understand what I'm trying to tell you here. Am I clear? Yes or no, guys?
Yes.
Yes, ma'am. Perfectly
Yes.
clear and
Yes.
audible.
Yes. So here, that is the reason why I say that ambiguous language should be avoided. There was one case, I remember, now I'll just give you a case about law. There was a company called, I don't remember the name of the company. It was a Canadian case, okay? Canadian company got into a contract with some other firm. And what happened is this company had a term clause. Now this term clause decides what is going to be, how long the contract is going to last. So in that case, there was one comma that was missed. And this case is from around 2006. The agreement had a term clause saying that this agreement shall continue for 5 years. And after this statement, there was a comma and shall be terminated by either party within 1 year notice. So now, when you say that this agreement is for 5 years, comma, and shall be terminated by either party with 1 year notice, that means, what do you think is the problem here?
But it implies 1 year notice should be given in advance to terminate.
Yes, but they're talking about a 5 years fixed period contract. And again, they're saying it can be terminated by any party within 1 year notice.
Yes, ma'am, it has both meanings.
Yes, it has two meanings. It is not even giving a specific termination. It is saying that you can terminate it whenever you want. Just 1 year notice you have to give. Then why have you given a term of 5 years? Right? So this is, and only because of the comma. If the comma was not present, it would be two different sentences. And then you could agree, you could argue that, 5 year term is also there. But when you say comma, you have options of doing both. It's not mandatory. You understand? It was optional after a point. Has everyone understood, or shall I explain it again?
No, that is about it. But
Yes.
only in fixed rate. But most of the things in this agreement happen if it's auto renewal contracts.
Yeah, but I'm giving an example where it was not an auto renewal contract. It was a fixed term contract for 5 years, and they put a comma after that and then said and can be obviously terminated within 1 year notice. So you
Yes,
give both the options, right?
yes, but mostly it's like accept as a customer standpoint of view. I can create an agreement stating that if the statement for 5 years, but anytime if you're not happy with the service, I can terminate within 1 year contract. And again,
Right,
notice I can give
right,
terminate. Yes.
right. But if they did not want to do that, it would have been unfair, right? If the comma was there, and that actually happened. What they tried to do is they showed 5 years, 5 years term, and then they just within 1 year they terminated the contract. And this did not even amount to illegal termination of the contract, because that's how the contract was interpreted by the court, because of giving two meanings to one clause. Am I clear? So as I
Yes,
told
ma'am.
you, uh, where we took that example is incorrect will be a party A will deliver the goods as soon as possible, and correct will be party A shall deliver the goods within 10 business days following the execution of the agreement. Am I clear? Then second is failure to define the key terms. Always understand there is a clause called definitions. Each contract will be specific. Each contract will have terminology very specific to that particular contract. Try to incorporate definitions which are extremely important to interpret the contract. Incorrect will be absence of a definition for confidential information in a non-disclosure agreement. When you get into a non-disclosure agreement, it is very important. Without definition of non-disclosure confidential information, you cannot get into a non-disclosure agreement. That is the basic need of the non-disclosure agreement. Because when you say non-disclosure agreement, you are saying that I don't want to disclose this information to anyone else. Now, when you say this information, how do you know this information? What is this information? This information is the confidential information. Now, who will decide what is confidential? The parties will decide, and the parties will define what is confidential and put it in the contract under definitions clause. Am I clear? Understood?
Yes, ma'am.
Clear?
Yes,
Good to
ma'am.
go?
Yes.
Perfect.
Yes, clear, ma'am.
Then we have overly complex or lengthy sentences. As I told you, no extra details are necessary. Utilize clear, concise language and break down lengthy sentences so that you avoid two meaning sentences. Incorrect will be, in the event of a breach, the party of the first may terminate this agreement without prejudice to other remedies. Correct will be, if party A breaches this agreement, party B may terminate it and pursue any available legal remedies. Now, there are two sentences which mean the same thing. Do you see the difference between two sentences? Isn't it difficult to understand the incorrect version of it? Yes or no, guys? Yes, it is very difficult to make any sense out of the first statement, but technically it's in proper English. So avoid complex language. Be extremely clear. Break down lengthy sentences into two sentences. Perfect thing to do. Draft the contract. Make your client read the contract. Ask your client whether you understand it from you. Because your client is the best person to tell you. The client does not come from a legal background. Okay, there could be certain words or terms which cannot be, overlooked or missed by you because those are necessary while drafting the contract. Definitely, those you have to consider. But English cannot be too complex when you're drafting. You don't have to change the meaning, just have to make it easy to understand. Unless you require by law to consider that particular term or use that particular term in sentence formation. Okay. Next is omission of essential clauses. Ensure the inclusion of key provisions such as termination, dispute resolution, and force majeure. Here we can also take the example of omission of definition of confidential information in non-disclosure agreement, right? Which we saw. Here, I've given an example that incorrect will be absence of a dispute resolution clause. Nowadays, without dispute resolution, you cannot get into an agreement, especially commercial agreement. So always have a dispute resolution. It's like a boilerplate clause. Boilerplate clause is a clause that will always be there in any contract. And when I say any contract, is any type of employment contract will have certain type of boilerplate clause. All the employment contract will have boilerplate clauses always. Definitely certain terms will change according to the needs of the parties. All type of non-disclosure clauses will always have certain type of boilerplate clause. Similarly, every commercial contract will have a dispute resolution. So the correct way will be including a clause which says any dispute arising under this agreement shall be resolved through arbitration in accordance with the Arbitration and Conciliation Act 1996. Am I clear? Everyone is clear until here?
Yes, ma'am.
Yes, ma'am.
Ma'am, by dispute resolution clause, we mean any type of area mechanism.
Any type of ADR. I've just given an example of arbitration, but you can take any type of ADR mechanism. Okay. So then we have failure to specify governing law and jurisdiction. Your contract's base is formed by the jurisdiction and the governing law. Now, governing law is not a big problem when you're getting into a domestic contract. But international contract, yes, you have to consider governing law. Why jurisdiction? Is jurisdiction will decide which courts you have to approach when there is a dispute. If you give jurisdiction to the Bombay court or Mumbai courts, or if you give it to Delhi courts, then you have to mention the jurisdiction. Okay, so this is how it works. Clearly define the applicable legal framework and jurisdiction. Incorrect will be a contract involving parties from different jurisdiction with no governing law clause. You cannot have two different jurisdictions for one contract. You have to decide on one jurisdiction. Correct will be this agreement shall be governed by and construed in accordance with the laws of India, and the jurisdiction can be given to the Delhi courts or whatever. Okay. Lack of logical structuring and formatting. Implement clear headings, numbering, and bullet points. So this is something related to formatting, nothing else. Your contract, when you look at it, should look organized. You can't have one important clause and something unrelated to it below it. Then again, something unrelated to it, but related to the first clause. No, it should look organized. And that is where the templates that you have to follow that comes into picture. When you take a sample clause, sample agreement, you don't have to copy paste it. You have to understand the flow of the contract. You understand the flow of the contract, the language of the contract. Take your party's situation, apply it, and then make your own agreement. Do not copy paste. Yes, certain clauses you will have to copy paste. You have to, because you have to use the same kind of language, but you do not have to exactly copy paste the clause. But maintain the logical structuring and formatting of the contract based on the sample you have taken. Understood, guys? Everyone clear with this?
Yes, ma'am. Clear.
Yes,
Yes,
ma'am.
ma'am.
Clear.
Yes, ma'am.
Yes, ma'am.
Okay, perfect. Exclusion of boilerplate clauses. When I say boilerplate is something that is always common in a particular type of contract. For example, NDA boilerplate clause is the confidentiality agreement definition. What is confidential information? Like I said, all commercial contracts will have a dispute resolution clause. For that, boilerplate clause is dispute resolution. So incorporate standard contractual provisions such as entire agreement. Now, entire agreement, severability, and amendment clause. Amendment is basically you're giving the authority to the party to make amendments in future. So that is logical, right? That is something you need to have in every contract. You can't just omit it. Right? So let's see the incorrect version. Omission of an entire agreement clause. Now, when you say entire agreement, means that the entire agreement that we have drafted or agreed upon is the final agreement. Whatever discussions we have had in past, or maybe a letter of intent, or maybe, pre-contract obligations we have signed, and they are no more applicable. This is the final draft, and this is something that is applicable onwards. Am I clear? The correct form will be this agreement constitutes the entire understanding between the parties and supersedes all prior agreements, whether written or oral. Clear with everyone?
Yes, ma'am.
Okay, perfect, perfect. Then comes lack of thorough review and proofreading. Conduct multiple levels of review. As I told you, more than drafting, you have to first start understanding how to do the review of the contract. Then eventually you can draft it really. Okay. Incorrect way will be overlooking contradictory provisions or typographical errors. We don't realize, but typographical errors actually make a lot of difference to the meaning of the sentence that is formed. Like how I gave you an example of the comma, right? So correct way will be ensuring legal and linguistic accuracy through rigorous review before execution. Then we have failure to address practical business consideration. The draft contracts that are legally sound while aligning with commercial realities. You can't draft something that is illogical and cannot happen in today's world. For example, incorrect will be impractical delivery timelines for supply chain agreement. Here, you don't need any legal knowledge. Here, your common sense comes into picture, right? You have to incorporate something. See, now when you're drafting the contract, all the information will be given to you by your client. You have to see how legally this is correct and incorrect. But if there's something, some information which you possibly think might get into, will put your client into dispute, for example, impractical delivery timelines, you have to advise your client or suggest your client that, this is very impractical. We cannot have a contract like this. And this is where your due diligence come into picture. Clear with this point? Okay. Then we have inadequate execution and signing formality. Verify that the contract is executed by authorized representative and witness where necessary. When your client is signing, let's say your client is signing on the behalf of a company because it's a commercial contract. You have to see whether the client is in capacity or the opposite party who's signing is in the capacity to sign the contract, whether the client has the proper authority given by the company to sign the contract or not. Or let's say it is unsigned. Okay, so here the incorrect thing will be an unsigned contract lacking execution detail. No contract can be executed whether if it is not signed, whether electronically or physically. An agreement signed by duly authorized representatives, dated and witnesses is required. Am I clear? Clear until here, everyone?
Yes, ma'am. We are clear. Ma'am, and
Yes,
one
ma'am.
more thing. Where do we get this Word document? Why? Because I'm watching in my phone, so I couldn't able to.
Yes, we'll share this. Don't worry. Okay.
Yes, thank you.
So this is, see, I'll tell you honestly, this is something very basic. We are trying to understand the common mistakes. If you even write it down, you'll be able to remember it. And that is the reason why I'm giving you examples so that, it's always something that is like rules that you have to follow when you're drafting. But anyway, this document will be shared. Now, there's certain cases which are very famous. Okay, there was one case regarding everyone knows McDonald's, right?
Yes.
So McDonald's had a lawsuit filed against them for a hot coffee. So what happened is, so now this, see, understand, when you're drafting a contract, you have to see it is fair. It is fair to both the parties. Okay. Uh, what happened is there was a lady, her name was Stella. She was 79 years old or something. She was driving back home or something. She went to McDonald's, she brought a cup of hot coffee. And while she was driving, she put the cup between her thighs and she started driving. What is going to happen next? What do you think? She spilled the coffee on her thighs. The coffee was served at 88 degrees Celsius, hot enough to cause third-degree burns in seconds. McDonald's technically had more than around like 700 prior complaints about the burns, but they never reduced the temperature. So what did Stella do? Stella went to the court, consumer court, and she sued McDonald's. McDonald's refused to give her medical bills for $20,000 she has asked. She took a legal action, and the judge punished McDonald's with $2.90 million in damages for negligence. So it's very important to be clear, fair, and protective of consumer rights when you're drafting a contract. Do you know, like, do companies like draft that favors only themselves? Do you know, like, as a lawyer, before I actually got into like drafting, I was always told that you have to secure your own interest when you're drafting. Do you know that? Have you heard the same thing?
Yes, ma'am.
But from this example,
But ma'am, in employment contracts, there is no other option to either accept it or deny it.
no, but see, I'm not saying accepted or denied. I'm saying when you are drafting a contract, even be it employment agreement, if you're the employer, everyone is told that you should always secure your own interest. Yes, you have to, because if you lose everything, it will be one-sided again. It'll be in your party, opposite party's favor. But what I believe in is when you're drafting a contract, you should always weigh both the sides, identify the strength and the weaknesses, and accordingly draft the contract. Such contracts which were mindfully drafted avoid future disputes. And that is given. That is something tested with time. So always be fair just when you're drafting the contract. I mean, definitely think about your securities and everything comes. But you have to be fair also, because if it's one-sided, you're going to pay the price for it. Because that is how it is going to be interpreted in the court also, if the opposite party goes to the court. Am I clear? Understood? So this is something we have to take away from the case study of McDonald's hot
Yes.
coffee case.
Yes, ma'am.
Okay. So here we have finished the part where we are going to understand something new. Does anyone have any doubts so far? Everyone has understood what we have learned today. Have you guys learned something new?
Yes, ma'am.
Yes.
Yes.
So today we majorly focused on understanding the mistakes one could make, right? And the consequences. What happens next if these mistakes are not, considered? The contract drafting course which we offer, we give the application of the knowledge. It is an interactive learning course where we engage in analytical review of multiple sample contracts and study them from a practical perspective. When I speak about employment agreement, we are going to have a very specific checklist for employment agreement. Okay. And this checklist is going to have the clauses. It is going to have the key consideration for each clause, because that is important to understand what a clause needs to be while drafting from that particular perspective of that particular contract. And then we also focus on what are the common pitfalls and eventually an example how this particular clause should be drafted for this particular contract. We also engage in group discussions during the course where we focus on tailored class activities. For example, we do a very intensive uh, negotiation activity, because with contract drafting, there comes negotiation of the contract. If you do not negotiate the contract properly, you're not going to draft a contract properly. It'll be an incomplete contract. Let's say even if you're not involved in the negotiation of the contract, only your client is involved, the information that you get from your client will tell you how the negotiations went if you understand how negotiation and what negotiations are. Okay. So that negotiation is just an example. Every class will have a drafting activity or some class activity that will give you a first-hand experience of contract drafting. Okay. Then we have live sessions. Definitely we have assignments to assess how you're doing and what you have achieved. This are conducted to reinforce the best drafting practices in this particular course. Okay. The key takeaways from the course are comprehensive checklist, we have structured templates, practical insight. I also explain the theory with, for example, let's say we are talking about employment laws, we are going to study the labor laws that are related to. If I'm teaching you, let's say, non-disclosure agreement, I'm going to talk about what are the laws related to. If I'm going to teach you how to draft a joint venture agreement, what are the types of joint venture? What exactly is joint venture? Okay. So with that, we give you hands-on experience in analyzing and correcting contract deficiencies with the practical class activities that we do. Okay. Here, this course will be helpful for you if you are a law student, someone who's aspiring to develop contract drafting proficiency. Is something I missed as a law student because we were never got access to such type of courses. So definitely a practical insight from how much ever experience I have, let's say 4+, 5+ years experience I have in contract drafting. All the inputs that I give in the class will come from the experience I have. If you're a junior legal professional who are seeking practical expertise, because in the start, you do not actually have first-hand experience, it takes longer. So you can curb on the time you need to understand things, right? If you're a business professional, not necessarily from a law background, but who is always involved into contract negotiation and management of contract, if not anything else, but just an individual who's interested in acquiring deeper understanding of contractual principles. So to enhance your drafting skills, you can enroll today to the course. So this is about the course, and this is about what are the common mistakes one can avoid while drafting. Am I clear?
Very
Yes.
clear, ma'am.
Yes,
Perfect.
ma'am.
Clarification. Okay, I opted for only for software contracts. That's only pays me. I work in a contract corporate work supporting US clients. So when you talk about different thing, I don't think it's not makes any sense for me. So just wanted to know this there won't be any impact on what I opted and the future sessions, right? Because I just want to only learn about software contracts. I don't want to know about legal
So
thing.
when you talk about software contracts, you're talking about SaaS agreement, software as a
Yes,
contract.
SaaS license, like
Yes,
the end
yes,
user user license.
we do cover SaaS licensing, everything.
Yes, I opted for only that training. So that's because that they mention is it's only for the overview. That's why I joined it. I just make sure that my
So this
understanding is
common
clear.
mistakes are something which you can also consider while drafting a SaaS agreement. So these were not very particular to any one contract. I just gave you an example of employment
Yes, yes, yes,
agreement.
right. I get
Yes,
it.
but this is something you can utilize for all types, just not for you, Jayasalan, but everyone in the class, in the webinar who's present today. This is something you can utilize for all types of agreements. Okay. Any, anyone else has any questions?
Yes, ma'am.
Yes.
Yeah, ma. And when you were speaking about the contract of signing by an authorized person, how can you determine in which the party is an authorized party, ma'am?
When I was defining the parties to the contract, right?
Yes, ma'am.
So that is
How
the
can you?
information you get from your client. So with this, okay, one thing I'll tell you. When we provide you checklist, right, particular to one contract, this checklist can help you form questions that you want to ask your client to grab information and draft that information in the particular contract you're drafting. It becomes easier because it's stepwise, clause wise. So if you understand the clause, let's say if you're giving me you're asking the question related to the definition of the parties. So this checklist will also have the idea behind the definition of parties, what one should consider while drafting. So all that consideration goes also to ask the same question to your client, and the client is going to give you the information, and accordingly you're going to draft. Have I answered your question?
Yes, ma'am.
Thank you.
Ma'am, and also McDonald's hot coffee case. Can you explain what is the difference between that she files in a case before consumer court and the agreement.
No, the agreement here, see, here am I trying to give you an idea. There's no agreement between her and, because there is a sale of coffee, right? Once there's
Yes.
sale of coffee, you have not written a contract, but that sale itself is an agreement. And this is how the consumers are protected. But
Right.
this example just shows that if you are being like stubborn about your own, you know, things that, my contract is going to be the way I want it to work, you're going to eventually fail, because that's how not the law or the courts interpret it. Definitely, if it is one-sided contract, the court by interpretation will say, no, 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 no. The other party is more weak. Let's focus on the most marginalized party. Am I clear, Swati?
Yes, I'm clear. Thanks.
Yes, ma'am. This case is very relevant, and also generally in every case, the court always focuses on the marginalized
Of
party
course.
or weaker side.
Yes.
Ma'am, could you please guide me like how to start learning contract drafting as a law student? Has there any particular resources or topic I should focus on first?
See, first I would say that if you have studied law, great, your theory part is clear with law, right? When it comes to
Yes.
contract drafting, see, especially in our course, what we do is we start with basics of contract. We understand what a contract is, what are the relevant things in any contract, not just, very specific. We understand the contract first. We understand the process of contract drafting and multiple levels, steps that are involved in contract drafting. Once that is clear, negotiation being one of the steps involved. Once that is clear, then we go to specific contracts. When we go to specific contracts, we also talk about the theory part of that terms which are going to be used while drafting the contract. I understand the idea behind getting into the contract and also how the particular contract will be done.
Thank you, ma'am.
Okay. Okay. There's a question in McDonald's case. Stella is having a liability to handle the product in due diligence. See, it is a coffee. It is coffee. Idea. Now apply your what do you say? Common sense. Coffee is supposed to be, you are supposed to drink the coffee, right? If you're drinking the coffee, one thing is for sure that the temperature should be controlled, because it's not safe to drink otherwise. 80 degrees, you know what is 80 degrees? You'll burn your tongue and it will give you third degree burns. So due diligence comes for both the parties, but here again the most marginalized one is going to be I mean responsive will be favored over the other one. Am I clear? Understood?
So in this case, the coffee was above the 80 degree. It was above the degree, normal degree, which is 80 degree. I'm right?
Yeah, I mean just yes, just an
Yes.
example.
Okay, right.
Okay, I think we are done with today's webinar. I think I can give it to Ria is here, the team, and I think the team will explain you the details of the course and the course better. So thank you everyone. Thanks a lot for being a very interesting audience to today's webinar. I hope everyone has learned something new, because that was the idea behind it. Looking forward to meet you all of you. Have a good day. Bye guys. See you. Thank you. Thanks a lot everyone.
Thank you,
Thank you,
ma'am.
ma'am, for providing such an insightful session. I'm sure it was highly beneficial for everyone. Can we all just give claps to ma'am through reactions? Let's appreciate her for sharing her knowledge with us and all. Thank you so much. Okay, all right. So I'm aware that many of you are currently waiting for the feedback form. So I'll be just sharing that in a minute. Before that, I'll be sharing the details of the course with you all. So kindly be patient and be on the call. So you can fill up the form up and then only leave the call. Okay. Yeah, just give me a minute. Okay, perfect. So, before sharing the feedback form, I'll be sharing the WhatsApp group link. Make sure that you join this group, because once the certificates are shared, we are going to update you in the group itself that your certificates have been shared. Okay. So, I hope so. You all have received the link of the group. Kindly just join that group if you are not there in the group already. Okay. Great. Okay, now moving on to next, I'll be sharing the details of the course. I'm sure by now you have understood the importance of contract drafting, and you are totally aware that the contract drafting skill is just not limited to India, but it will also help you internationally if you want to work all over the world. Let's say if you want to work in Dubai or anywhere, America or anywhere else you want to work, contract drafting is a skill that will help you a lot in creating your career, irrespective of country boundaries. Okay, so some of you were interested in software contracts. Now I know that this topic might be confusing for people who are not aware of it. That what's the difference between general contract and software contract? So the major difference between both the contracts are, when I'm talking about general contracts, it refers to your contracts that comes into use on day-to-day basis irrespective of industry. So when I'm saying IT contracts or software contracts, these are the contracts majorly used by IT people or software companies like Infosys, Wipro, TCS, and much more. So, how these contracts are beneficial? When I'm purchasing a software, of course, there will be a transaction between me and the client, right? So, that's where the software contract will come into use. There will be exchange of license, there will be a contract which will focus on IT terminology. That's why it's a software contract. Now, if you have any query with regard to the both the topics, we can discuss much more in detail. I'll be just quickly sharing my screen. We do have a course on software contracts as well. Let me just know if my screen is visible to you all. Is it
Yes, ma'am.
visible?
Yes, it's visible.
Okay, great. So, we the contract drafting course, which ma'am discussed right now, is going to actually start from 7th April. That's Monday. The timing for the classes will be 7:30 to 8:30 p.m. evening sessions, and we also provide you with the recordings of the same. In case if you miss out on the session, you will be having access to the recordings on the same day. Now, in each LeDroit course, we cover all the topics from basic. So, irrespective of whether you are completely a fresher, whether you are a professional, we are going to cover every topic in detail. The duration of the course is 15 days. We keep the duration of the course short so that you have your interest intact. Because if we are going to, you know, keep the duration of the course for 1 month, 2 months, I don't think so. It's possible for everyone to pay proper attention to it. But when we keep the duration short, you are able to grasp knowledge in much more better manner. You are able to learn things in a better manner. So without affecting the quality, we cover everything from scratch. So initially you'll be learning about the contract law, the basics of the contract law, what are e-contracts, how e-contracts are drafted. Then we are going to cover standard form of contracts, importance of standard forms of contracts and what are their purposes. Then we are also going to learn about registration of contracts in India. So in contract law course, we are majorly going to focus on Indian laws. However, if you are from some other country, you can still go for this course. And because contract law uh, can differ from country to country, but there wouldn't be any major difference in it. Next is what are the contracts which we are going to cover in the course. Of course, we are going to discuss about breach of contract and common breaches type of damages. Then we are going to discuss about the major contracts that are used in industry, that is master service agreement, your time and material contracts, non-disclosure agreements, employment contracts, and much more. So all these topics are covered in the course. Not only that, there will be practical assignment sessions as well, where you will be drafting a contract from scratch and you'll be receiving a face-to-face feedback on your performance. So towards the end of the course, the final session is a feedback session where faculty reviews your assignment and give you personalized feedback on your performance. There will be interactive contract negotiation session as well, where faculty is going to actually sit and teach you the skill, the art of negotiation. She's going to share her tips and tricks on how to negotiate a contract, what are the things to consider while sitting in a contract negotiation session. Okay, so with that, do you guys have any doubt with regard to this? I'll just cover up that what are the things you'll be receiving in the course. You'll be receiving reading materials, which will cover everything in detail. You will be receiving recordings that you can have access to for a period of 2 years. You will be receiving certificate towards the end of the course, and of course, the sample drafts of the contract. Each contract that has been mentioned in the course will be shared with you all. So currently the price for the course is INR 1800. The actual price for the course is actually 2500, but under the offer we are providing you at 1800. That is valid till today. And another skill, if you are interested in creating your career in corporate sector, so I'm going to share details about two more courses with you that will be highly beneficial for you. So there's one more course on contract life cycle management. Now we discussed that the contract drafting is just not a skill limited to drafting. It comprises of negotiation, abstraction, reviewing a contract, and there's much more to it. So when people are hiring you, they just not only focus that whether you have a drafting skill, they focus much more on whether you have skills related to contract management. It's an altogether a different field in corporate sector, and it is highly in demand because people are looking out for people who have expertise on managing a contract and working on the two. This is a completely practical course that will majorly focus on skills like how to review a contract, what is a CLM, that is contract lifecycle management, what is your contract abstraction, how do you have any expertise on working on the tool. So we have in the past we have received students who have actually got benefited from this course and actually attended this course to just to get a job. So this skill will highly help you. We also provide you insights on how to sit for corporate interviews, how to answer questions, what type of questions you can expect during your interview, and we give you proper guidance on the same. Any doubts with regard to the two courses which I've shared? We also have a combo offer going on right now that provides you both the courses, contract drafting and contract lifecycle management, together at just rupees 2200. Again, this offer price is there till today only. So we'll be sharing the details of these courses along with the registration link in the group which you have joined. You can go through there, or you can um, you know visit the website of LeDroit, www.ledroitindia.in, and from there you will be having access to the course details and everything. Okay, now I'll be just sharing the details of one more course, that is software contracts drafting. The major focus of this course is to cover the IT contracts. The IT contracts that are used in IT industry, such as software agreements, software license agreements. We are going to cover the key terminologies used in IT industry. Uh, for example, we are going to explain different type of licenses, what are milestones. We are going to cover much more terminologies in detail. Everything will be covered from scratch. We are going to discuss about software license agreement, software license and support agreement, types of software license agreements, and we are also going to discuss about software outsourcing agreements. And again, it will be the same, that towards the end of the course there will be a practical assignment where you are going to draft a contract and will be getting face to face feedback on your performance. The duration of this course is 12 days, and the fee for the course is currently 1500. The course will be starting from 18th of April. And yeah, that's all about the three courses that I shared with you all. If you have any query with regard to the same, let us know. You can also reach out to the admins of the group. Now, coming on to your queries, yes, you'll be receiving recordings. Okay, you'll be. I can see that there are many people who are from India and not from India. So we'll be sharing the feedback form over here. Okay, just give me a minute. With regard to your certificates, only students who have attended the seminar will be receiving the certificates. So kindly fill up the form and then only leave the call. Let me just know if you can see the form. I'll be sharing. Can you all have access to the form? Kindly just confirm. With regard to the recording of the webinar, you can have the recordings of the webinar on our YouTube channel or in the group link which I shared earlier. We'll be sharing the recording as well as the material which ma'am was showcasing during the call will be shared with you all. I'm just resharing the link. Please fill that up, then only leave the call. In case you haven't filled up the form, we won't be able to provide you with the webinar certificate. Also, one more thing. The certificates will be shared to you within a week's time. So kindly be patient till next Sunday or Saturday. By then, we'll be sharing your certificate. Students who haven't received the certificate for sales of goods at course, will be kindly drop a text to us at this number or drop us a mail. I'll be sharing the mail ID where you have to drop a mail so we can look into your query. Just give me a minute. You can drop us a mail for your certificate issues at this mail ID, or this mail ID is also available on our website. You can drop us your full name, the course name, or the webinar name, and the date you attended. We'll look into your query and resolve the same. I am again sharing the link in case you guys are not able to access the same. Please fill up the form, then only leave the call. Thank you so much for attending. We'll highly appreciate if you all guys can give us feedback on our Google page as well and support us, because we will be conducting more sessions like this in future as well. Every month we conduct 2 or 3 more such sessions. So yeah, that's all. Stay connected with LeDroit India for getting more practical sessions like this. Thank you so much.